Good evening. Tonight we are following a rapidly developing constitutional situation in Washington that could test the boundaries of executive power, congressional authority, and the chain of command of the United States military. At 6:42 a.m. Eastern Time, the White House released a brief written statement announcing that the president had signed an executive directive suspending the certification of the upcoming federal general election, citing what the administration described as credible and ongoing foreign cyber interference threats. The directive ordered the Department of Homeland Security to conduct a nationwide audit of state-level voting infrastructure and instructed federal agencies to prepare contingency plans for what it called a delayed national electoral timetable. Within minutes, legal scholars and state officials began raising a fundamental question. Does any president have the authority to delay or suspend a federal election? By 8:15 a.m., the Department of Homeland Security confirmed that it had received instructions to deploy federal cybersecurity teams to several states. However, multiple governors publicly stated that they had not requested federal assistance and had not been presented with specific intelligence justifying such action. At 9:30 a.m., the Speaker of the House issued a statement declaring the executive directive without constitutional foundation and announced that House leadership was preparing emergency legislation reaffirming Congress's authority over federal election scheduling. The timeline intensified just before noon. At 11:52 a.m., the Department of Justice filed a sealed memorandum in federal district court seeking declaratory support for what it described as the president's inherent authority under Article 2 to protect the integrity of national elections during extraordinary foreign threats. That filing has not yet been made public, but sources indicate it relies heavily on national security powers and the president's role as commander-in-chief. The Constitution, however, assigns specific authority regarding federal elections to Congress. Article 1, Section 4 states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulations. Presidential election dates are set by federal statute. There is no explicit constitutional mechanism allowing the executive branch to unilaterally delay a federal election once Congress has set the date. By early afternoon, reactions from the states began to diverge. The governor of California stated that the state would proceed with its election timeline regardless of the federal directive. The governor of Texas similarly affirmed that state election infrastructure would operate according to existing law. Several swing states issued more cautious responses, indicating they were reviewing federal guidance while seeking clarity from the Department of Justice. At 2:05 p.m., the Senate Majority Leader announced that a bipartisan group of senators was requesting an immediate classified intelligence briefing to determine whether the alleged cyber threat justified extraordinary federal intervention. The Department of Defense entered the conversation at 3:18 p.m., issuing a brief statement emphasizing that the military remains apolitical and will not participate in domestic law enforcement activities except as authorized by statute. The statement referenced existing limitations under the Posse Comitatus Act, which restricts the use of federal armed forces in civilian law enforcement absent specific congressional authorization. That statement was widely interpreted as a signal that any attempt to use active duty forces to secure polling locations or seize election infrastructure would face significant legal and institutional barriers. Meanwhile, at 4:40 p.m., a coalition of state attorneys general filed an emergency lawsuit seeking an injunction to block enforcement of the executive directive. They argue that election administration is fundamentally a state function, constrained by federal law passed by Congress, not executive proclamation. As the legal filings moved forward, the situation escalated further. At 6:12 p.m., a memorandum from the Office of Management and Budget was circulated to federal agencies, instructing them to prepare contingency funding allocations in the event that the national electoral schedule is adjusted. That language intensified concern on Capitol Hill, where members of both parties began discussing whether the executive branch was preparing for a scenario in which the election date could effectively be altered without legislative approval. The constitutional implications are significant. Under the 20th Amendment, the terms of the President and Vice President end at noon on January 20th. If no president has been chosen by that time, Congress has established statutory succession mechanisms. The Presidential Succession Act provides that if both the presidency and vice presidency are vacant, the Speaker of the House may act as president until a qualified successor is chosen. Therefore, even if an election were delayed, the expiration of the current term would remain fixed unless amended by constitutional revision, an extraordinarily high threshold requiring 2/3 of both chambers of Congress and ratification by 3/4 of the states. Late this evening, the Chief Justice convened a special administrative session with senior federal judges to discuss expedited review procedures. While the Supreme Court has not yet agreed to hear the matter, legal analysts anticipate that emergency applications could reach the court within days, if not hours. The conflict now appears to be moving toward a three-branch confrontation. The executive branch is asserting national security authority. The legislative branch is reaffirming its constitutional power over election timing. The judicial branch may soon be asked to determine the limits of presidential emergency powers. There are additional layers. Intelligence officials have privately indicated that while foreign cyber probing has been detected, it is not unusual in election cycles and that no confirmed breach of vote counting systems has occurred. However, those assessments remain classified, and public confidence is being shaped by incomplete information. Financial markets reacted sharply in after-hours trading, reflecting uncertainty about the continuity of governance. Bond yields moved slightly upward, while volatility indexes rose in response to perceived institutional instability. Within federal agencies, internal guidance has emphasized continuity of operations. Senior civil servants have reportedly sought clarification regarding their obligations should conflicting legal orders emerge from different branches of government. The potential escalation paths are becoming clearer. The first scenario involves rapid judicial intervention. A federal court could issue a nationwide injunction blocking enforcement of the executive directive, preserving the statutory election date while the case proceeds through appellate review. In that scenario, the immediate crisis would be contained within the legal system, though political repercussions would remain. The second scenario involves partial compliance and fragmentation. Some states could attempt to follow federal guidance while others refuse, resulting in a patchwork of election procedures that could trigger disputes over certification of electors, leading to contested electoral votes when Congress convenes to count them under the electoral count reform framework. A third, more severe scenario would involve a constitutional standoff extending beyond Election Day. If the election were materially disrupted and no certified winner emerged by January 20th, the line of succession would activate. That could produce a temporary transfer of executive authority under statutory provisions, even while legal challenges continued. Historically, the United States has confronted constitutional crises before. During the election of 1876, disputes over electoral returns required congressional intervention and a special commission. In 2000, litigation over ballot counting procedures culminated in expedited Supreme Court review. However, in both instances, the scheduled election date itself was not suspended by executive order. The present situation raises a more direct structural question. Can national security concerns override statutory election timing without explicit congressional authorization? The answer may hinge on how courts interpret the scope of executive emergency authority, and whether the judiciary views election scheduling as a core legislative function beyond unilateral presidential adjustment. As of this hour, the Department of Homeland Security has not deployed federal personnel to any state polling facilities. Governors continue to assert control over their election apparatus. Congressional leaders are preparing emergency floor sessions for tomorrow morning. The coming hours will determine whether this conflict remains a legal dispute resolved within institutional frameworks or evolves into a broader test of constitutional equilibrium. At its core, this moment is not about cybersecurity alone. It is about the distribution of power among the branches of government and the fixed calendar mechanisms embedded in the Constitution to ensure orderly transfer of authority. The framers designed staggered terms and precise expiration dates to prevent uncertainty from becoming instability. Whether those guardrails hold under the pressure of executive emergency claims is the question now confronting the nation. We will continue monitoring court filings, congressional proceedings, and executive responses as this story develops. This is a developing constitutional situation with potentially historic implications for federal authority, state sovereignty, and the continuity of democratic governance. We will bring you verified updates as events unfold.